Hello, I am Dr. Dolly Jabul, an associate professor and a registrar in charge in the National University Orissa. Today, I'll be discussing with you a lesson which of course is with regard to feminist jurisprudence. And here of course we'll be looking through the perspective as in where we will be discussing it through topics. That is, the first is through from practice to theory. It's of course a renowned author, which of course I was going through this article, which did attract my study, which did attract her study for me to see that how she had studied the environment which of course existed in India. And for that, we need to see that, yes, taking some glimpses of her article, going through the conceptual perspective, and then after that I'll be discussing the various cases of the Supreme Court to see how the particular concept of feminist jurisprudence has evolved in India. Feminism is not susceptible to a simple definition as it possesses many strands, and feminists themselves differ widely regarding issues of substance and method. Nevertheless, the feminist movement is grounded in the idea that the lives of women and girls should not be determined solely by gender. The women and girls should be able to exercise a modicum of choice if they're in their lives, and that they should be entitled to dignity of the person. Consequently, feminism, inspired by the vision of the way things might be, in a pragmatic or a reformistic movement which seeks to make things better for women in all spheres of life. Following on the heels of practice in academic jurisprudence, in academic feminism, critics of the gender construction of knowledge has been central to the feminist project in the academy. What has been progressively established in respect of masters' discourses of all academic disciplines is that the account that has been presented in a universal and the truth are in fact practical because they focus more exclusively on masculinist knowledge. Therefore, the threshold question of academic feminism has been how can rational claims to universality be made if the experiences and perspective of women are omitted. Feminists, sociologists, and anthropologists were in the vanguard in the developing critics of knowledge in the new discipline of women's study in the year 1970s. For the social sciences generally accepted by then that gender was the legitimate category of analysis. At first, the gatekeeper of the academy were prone to dismiss feminist scholars as politics or not real. But women's study helped to give feminism a degree of academic respectability despite the initial struggles. From the outset, feminist scholarship was very much concerned the interrelationship between theory and practice. The point is illustrated by the ongoing attempt by feminists to draw attention to and disrupt the philosophical and political separation between public and private lives. Indeed, one of the early movements, that is the feminist movement, was that personal is the political, which suggests that everything that occurs in the home and has been formally accrued by the taxpayer of the private should be matter of public concern. The feminist gaze on the private spheres by permitted not just a critic of family law and domestic violence, but it has also enabled the exploration of the symbolic relationship between private and public spheres, that is, the way in which women's responsibility for children, the sick and the elderly as well as their responsibility for housework, for facilitating the participation of men in paid work, in civil society and public life. While law is less overtly hostile, the legal academy to continue to be resistant for feminist scholarship because it challenges the well-entrenched liberal myths that the legal person is genderless, that one's life course is determined by personal choice, and that law has universal application. The correlative myth of law's neutrality, objectivity, and non-partnership are also deep-seated and indeed center to cherished legal concepts such as the rule of law and equality before the law. The ideological role of law is maintaining social coherence and transmitting dominant values has been deeply destabilized by the subversive nature of feminist scholar. Now, to see this topic through the constitutional perspective, the role of the Constitution is envisaging gender justice is being recognized in modern times. It is most appropriate that the supreme law of the land should meaningfully address the women question and respond to the challenges by stimulating the whole legal system towards a greater concern for and protection of women. Feminism is a range of committed inquiry and activity dedicated to first understand the extent of women's subordination, know the reasons thereof, and plan and implement meanings of change for the better life. Constitutional feminism means in employing the constitutional powers and provisions for the emulating the conditions of women. All the wings and layers of government, legislatures, executive and judiciary at center, state and local levels have been responsible towards enforcement of women in the light of Article 15(3) read with Article 12 of the Constitution. Although Article 15(3) is an enabling provision that it authorizes the state to make social provisions for women, the discretion conferred thereunder should be exercised without fail and be exercised reasonably. It is also fundamental duty of every citizen to renounce the practice derogatory to the dignity of women. Thus, social and individual responsibility for feminist cause are contemplated in additions to democratic solutions. No doubt, democracy provides equal opportunity for all in the decision-making process. Women is free citizen and constituting almost half of the population are theoretically able to redress their grievances through democratic means, but due to the socio-economic reason and the cultural pattern that are not effective players of the games of democracy. The disadvantage of democratic process and risk of parliamentary majoritism makes it imperative that a pro-woman and an anti-subordination interpretation of Constitution and law shall be made. In a practical social construction where power dictates freedom, lack of power on the part of women because of their position as incompetent agents in democratic participation is likely to marginalize their freedom. To control the lacuna and make freedom worthwhile to women empowerment emerges as the true method of freeing women. Thus, instead of uncritical reliance on democratic forces, appropriate technique of interpretation can reduce their interest. One such approach is democratic analysis as distinct from different analysis. Catherine McConney, an American feminist scholar views gender as hierarchy and not just as difference, and argues the ethos to treat gender as a question of difference are misguided, and the gender should be understood to be matter of domination and subordination. While the different analysis just satisfies with formatic, reasonable explanation about different bases on sex, domestic analysis to the substantive issues of unfair disadvantages arising from dissonance. For example, upholding of a rule which denies to women on grounds of their safety an opportunity to work as jail officers in prisons which house man prisoners is relying on different analysis, but the dominance analysis examines how the aggrieved male sexuality results in unfair rule of law principles, simply reflects rule of man, but not justice, and intuitive justice reviewed is invited. Thus, we see the Indian Constitution also addresses somewhere the lawmaking process, the feminist jurisprudence. Now we move on to the judicial intervention. Along with that, the conceptual perspective of feminist jurisprudence. Thank you. Now, looking through the conceptual perspective, we see jurisprudence in its most ordinary meaning refers to the science of law, and it includes both the science and civil law and criminal law jurisprudence. The philosophical genesis of jurisprudence has been subject matter of intense intellect debate, and the 20th century witnessed, amongst others, the development of the concept of feminist jurisprudence. Feminist jurisprudence originally means asking how the law would be different if it took women's point of view and experiences into account while decoding legal concepts and working of law in real world. Traditionally, law follows gender neutral approach, that is, it does not differentiate between man and woman and envisages equal rights for both men and women in a given society. The gender neutral approach has been criticized by feminists as a goal that is impossible for one and not desired by the others. The above concerns the basis of feminist jurisprudence, which is essentially socially critic, that is, it depends upon the social and the cultural ethos of a given society and the freedom and status enjoyed by women in the given society. Indian conception of feminist jurisprudence is not divergently different from the Western concept of feminist jurisprudence, which owes its origin to Professor Anne Scales, who, in her article entitled Towards a Feminist Jurisprudence, coined the term in the year 1978. In India, it is concerned in a much narrower perspective of women critic law and legislations like protection against sexual harassment in workplace, concept of maternity leave for working women, etc. In India, most of the development can be attributed to the judicial lawmaking, that is, different directions issued by the Supreme Court of India in the Kathina of decisions, which are discussed in brief in the following slides. The first where we go through, which of course I have not kept them in order, but first we witness it through Geeta Hariharan versus Reserve Bank of India 1999 Supreme Court case. The court was faced with considering Section 6A of Hindu Minority and Guardianship Act 1956 and Section 19B of the Guardian and Wards Act 1890. The sections were challenged as violative of the Equality Clause of the Constitution, inasmuch as the mother of the minor is regulated to an inferior position on ground of sex alone, since her right as a natural guardian of the minor is made cognizable only after the father. The court relied upon the Convention of the Elimination of All Forms of Discrimination Against Women, 1979, that's called as CEDAW, and the Beijing Declaration, which directs all state practices to keep appropriate measures to prevent discrimination of all forms against women, is quite clear. It was held by the court that the domestic courts are under an obligation to give due regard to the international conventions and norms for considering domestic laws when there is no inconsistency between them. The court was faced with the constitutional validity of Regulation 46(1)(c) of the Air Indian Employee Service Regulations. It was provided that the services of the air hostesses would stand terminated on first pregnancy. The court, after considering various U.S. Supreme Court judgments regarding pregnant women, held that the observations made therein would appear to be domestic cases. In Municipal Corporation of India versus Female Workers Muster Roll and another 2000 Supreme Court case, the short question which was to be decided by this court was whether, having regard to the provisions contained in Maternity Benefit Act 1961, women engaged on casual basis or on muster roll basis or daily wages, and not only those in regular employment, were eligible for maternity leave. The court, upholding the right of a female worker to get maternity leave, relied upon the doctrine of social justice as embodied in Universal Declaration of Human Rights Act 1948 and Article 11 of the Convention of the Elimination of All Forms of Discrimination Against Women, held that the provisions of the same must be read up unto service contracts of municipal corporation. Madhu Keshwara and others versus State of Bihar and others, 1996 Supreme Court case, challenge was made to certain provisions of Chota Nagpur Tenancy Act 1908, providing succession to property in the male line in favor of the male on the premises that the provisions are discriminatory and unfair against women and therefore ultra vires the equality clause of the Constitution. The court, while upholding the fundamental right of the tribal woman to the right to livelihood, held that the state was under an obligation to enforce the provisions of the Vienna Convention on the Elimination of All Forms of Discrimination Against Women, that is the CEDAW as known in short, which provided that discrimination against women violated the principle of equality of right and respects for human dignity. In a landmark judgment, that is the Vishakha and others versus State of Rajasthan and others, AIR 1997 Supreme Court case again, the writ petition was filed for the enforcement of the fundamental right of working women under Article 14, 19 and 21 of the Constitution of India, with the aim of finding suitable methods for realization of the true concept of gender equality and preventing sexual harassment of working women in all workplaces through judicial process to fill up the vacuum in existing legislation. The court, while framing the guidelines and norms to be observed by the employer in workplace to ensure the prevention of sexual harassment of women inter alia, relied on the provisions in the Convention on the Elimination of All Forms of Discrimination Against Women, as also the general recommendations of CEDAW for considering the nature and ambit of constitutional guarantee of gender equality in our Constitution. In another case, in Ranbir Singh versus Union of India, 1982, a Supreme Court case, the court, while holding that non-observations of the principles of equal pay for equal work for both men and women under Article 39D of the Constitution amounted to violation of Articles 14 and 16, recognized that the principle was expressively recognized by all socialist system of law, including the preamble to the Constitution of the International Labour Organization. Lastly, to conclude, where we see that in my end note, where I have provided the Supreme Court of India in its observations recorded in Anuj Garg and others versus Hotel Association of India and others in Civil Appeal number 5657 of 2007 points to the judicial attitude towards feminist jurisprudence in India is noted that the heightened review standard a precedent establishes does not make sex a proscribed classification. Supposed inherent differences are no longer accepted as a ground for race or national origin classification. Physical differences between men and women, however, are enduring. Inherent differences between men and women we have come to appreciate remain cause for celebration, but not for denegations of the members of either sex or for artificial constraints on an individual opportunity. Sex classifications may be used to compensate women for particular economic disability they have suffered, to promote equal employment opportunity, to advance full development of the talent and capacity of our nation's people, but such classification may not be used as they were once to create or perpetuate the legal, social, and the economic inferiority of women. No law in its ultimate effect should end up perpetuating the obsession of women. Personal freedom is a fundamental tenet which cannot be compromised in the name of expediencies unless there is a compelling state purpose. Thank you.